And our guest this week is Dr. Roger McEowen, who ag law professor and the tax specialist at the Washburn University. And of course, Roger's done a lot of tax seminars. A lot of folks have been at the time at K-State, Iowa State, and here at Washburn as well. And we will let folks know how to get more information about these topics. The next one, Roger, is one that we don't deal with a lot here, but could have impact in Kansas, and that is simply right to farm.
That's right. Every state has a right to farm law, and they vary in their types, but Kansas does have one. And there's the Indiana statute may be on its way to the United States Supreme Court, and it's not every day we get to see a right to farm law be perhaps considered by the U.S. Supreme Court. It happened in 1998 with the Iowa statute, and they refused to hear the case that time. But now the facts and the outcome are kind of flipped around. In the Iowa case, the Iowa Supreme Court unanimously held that one of the two versions of the Iowa Right to Farm Act was actually unconstitutional. And the U.S. Supreme Court declined to hear that case to possibly overturn it. But what happened in that one was you had a right to farm law that, at least in part, gave the authority to the County Board of Supervisors, which is the counterpart to county commissioners in Kansas. And they said, well, farmers can petition the county board for, I believe it was a 900-acre area, and the farmers in that area cannot be sued on a nuisance theory. And what they were trying to do is provide protection to confined hog operations, particularly in northwest Iowa. And the court said, you can't do that. That's unconstitutional, because now you're saying the people that are just outside the designated area that are affected by the odors don't respect boundaries, can't sue for a nuisance. And you can't do that. That's a taking of a private property right, the right to be free from nuisance, and it's a bestowing of an easement to create odors on the part of the farmers that are in the area. Well, the Indiana statute, and these right to farm laws are good laws, because the whole idea, by the way, Ken, is we want to have a provision that says if I'm a farmer and I'm out there farming, minding my business, I've got all my state and federal permits, and I'm using good husbandry practices, and then somebody develops next to me and they move in and they buy an acreage and they come next to me. Well, it wouldn't be fair for them to complain that during harvest season it's dust and there's lights at night, and there's noise, and if I've got livestock, then there are odors, and it's not the pastoral quiet scene that these people from town thought it would be. So it's not fair that they should sue. Well, the Indiana statute, and a number of other states have done this in recent years, is they've said, well, we want to provide additional protection to farming operations and say, if you were there first farming and then somebody moves in, you can then modify your farming operation to whatever you want to do. If you want to go from row crop to thousands upon thousands head of livestock, you still are grandfathered in, so to speak. You can't be sued on a nuisance theory because you're still ag. And this created a case in Kansas or in Indiana involving the same family members, different generations. And the Indiana Supreme Court said, yeah, you can increase your size of anything. You can go from row crop to 8,000 head of confinement hogs, a quarter mile away from grandpa's home, and grandpa can't sue. And so the Indiana Court of Appeals upheld that, and there's been a request by the United States Supreme Court to hear the case. So we'll have to see what happens.
Well, Roger, I think that's going to be very interesting, something to keep our eye on as, many of us look to possibly expand livestock in certain areas and certain ways. So I think this could have implications even beyond, as we look at moving forward. So, Roger, if folks want to learn more, and we just scratch the surface on both these issues. TV sometimes cuts down our time. So if they want to read more of your thoughts on noxious weeds, as well as possibly right to farm, going at least a state right to farm, going to the Supreme Court, how can they learn more, and how can they follow along with other of your thoughts?
Sure, they can go to my website and they can find my blog. These are what we're referring to here are two recent articles I posted on my blog. I do that about 130 times a year with these detailed articles. And down the left-hand side of my homepage, they'll find a link for the Agricultural Law and Taxation blog. And there's another link they can sign up for an email alert. So they can get an email alert every time I add something to the site. And that's just washburnlaw.edu/Walter, WALTR, the Washburn Agricultural Law and Tax Report.
All right. Well, as always, great to catch you up. I'm sure we'll do this again here, probably the next maybe couple of weeks or a couple of months anyway, when more issues come up, and we'll maybe see what develops with these as well. So thanks for your time.
Sure. Thank you, Ken.
Roger McEowen from Washburn University, another session of Ag in the Courtroom. Stay with us. We'll have more coming up.